We never wanted to get to this point where it had to be brought before a judge. If it had been properly vetted during the session, we would have addressed these issues instead of having it railroaded through the legislative session.
Just because you think I don't have the money to pay for school doesn't mean that I don't have the same hopes and dreams for my children.
Strong reaction today from both sides in the lawsuit over the state's controversial school voucher program. Judge Tim Kelly has ruled that the way the state is paying for the program is unconstitutional. He says the voucher program itself is legal, but MFP dollars can't be used to pay for it. Two state teachers unions argued that public dollars must go to public schools. Lawyers for the state say the Constitution does not prevent the government from educating children by giving them money to attend private schools. The state plans to appeal. Now, Louisiana School Choice Act was actually challenged in two separate courtrooms this week. Southern Ed Desk reporter Sue Lincoln has our trial coverage.
This week of legal proceedings involving Louisiana's School Choice Act began in federal court with a hearing in the 47-year-old Tangipahoa Parish desegregation case. The plaintiffs and defendants in Moore v. Tangipahoa Parish School Board asked that the voucher program and other provisions of the statewide education reform plan be halted in their district. They say vouchers are increasing segregation and are siphoning off funding needed for compliance with the federal consent decree. The judge put a stop to the program, saying it conflicts with the desegregation case. Attorney for the Tangipahoa Parish School Board, Charles Potan, is happy with U.S. Justice Ivan Lamel's ruling.
We're pleased with the ruling, obviously. We think the court is on sound ground in its decision.
Jimmy Faircloth, the attorney representing State Superintendent John White and the State Board of Education, was less pleased.
I honestly do not understand what it is about Act 1 or Act 2 that prevents them from complying with the deseg order. We made that point. The court viewed it differently, but I, as I stand here, I really don't understand what it is they're not able to do because of these statutes.
Faircloth says this battle is not over.
It's a temporary, it's not a permanent injunction. The court reserved the right to rule on the permanent injunction. So those issues will be decided later, and we will likely take an appeal from this ruling to the Fifth Circuit.
The ruling could impact school districts statewide. That's exactly why Potan says he hopes this is not the end either, rather just the beginning.
I'm most hopeful, since there are about 35 or 40 other school districts that are under court order, that each and every one of them will file a similar action immediately.
Before the state trial on the constitutionality of the school choice law kicked off Wednesday morning, there was a rally put on by supporters of the voucher program, the Black Alliance for Educational Options, and parents of voucher students. Valerie Evans is one of those parents.
This scholarship program represents a crisis solution to a crisis problem. We have been in a crisis for a long time, and I, as a parent, should not have to suffer and sit back and watch my child or any child try to learn in an unhealthy, unsafe environment.
But the Louisiana Federation of Teachers, Louisiana Association of Educators, and Louisiana School Boards Association are challenging the constitutionality of Act 2 and its funding mechanism. Among their assertions, that Act 2, which repeals 3 statutes, amends 26 existing statutes, and adds 19 new statutes, violates the one bill, one object requirement of the state constitution. LFT President Steve Monahan.
It's in the Constitution that if a bill is presented to the legislature, it is to have one purpose, one intention, so that the focus, the vote of that legislator is going to be on that one item.
Plaintiffs also contend that Act 2 violates the state constitution by allowing public tax dollars to be sent to private schools.
The Constitution of Louisiana is very clear in Article 8 when it indicates that the minimum foundation program, the state funding mechanism, is to be used to fund public elementary and secondary education.
State Representative John Bell Edwards, a member of the House Education Committee, is among the witnesses called to testify in the case.
Local tax dollars were going to be captured and redirected to private and parochial schools, a purpose for which the local taxpayers didn't approve when they put those taxes on themselves, and doing it through the MFP that only speaks to to public elementary and secondary schools. So I think it's bad policy, but I also think it's unconstitutional.
Once again, Jimmy Faircloth is representing the state in this case.
We're defending the constitutionality of those statutes. So they've got to prove they're unconstitutional. We believe they're clearly constitutional. In fact, all laws are presumed constitutional.
Monahan says one thing is certain. This trial will not be the end of the issue.
Regardless of what the interpretation is of the court, we all know what's going to happen next. This court, it's going to be appealed, either side.
And Monahan doesn't believe that appeals process will be completed until after the current school year has ended. For the Southern Education Desk, I'm Sue Lincoln.
Now, the Southern Ed Desk is a partnership among public radio and television stations across the Gulf South. We delve into a wide range of educational issues from kindergarten through 12th grade and higher ed. For more information, log on to southerneddesk.org.